5, 4, 3, 2, 1. Start. This is a civil appeal arising out of a matrimonial dispute, where the appellant husband challenges the judgment and decree passed by the learned family court, which declined to grant a decree of dissolution of marriage. The appeal has been filed under the appropriate matrimonial legislation governing personal relationships, seeking judicial intervention on grounds of cruelty and irretrievable breakdown of the marital relationship. The facts, as gathered from the pleadings and arguments advanced by both parties, are briefly set out as follows. The marriage between the appellant and the respondent was solemnized approximately 12 years prior to the filing of the divorce petition. It was an arranged marriage, conducted in accordance with customary rites and ceremonies recognized under the prevailing personal law. At the time of marriage, both parties were gainfully employed and their families were well acquainted. There were no initial complications reported during the early years of matrimonial cohabitation. The appellant contends that within a few years of the marriage, serious incompatibilities began to arise between the spouses. According to the appellant, the respondent exhibited behavior that was persistently hostile, verbally abusive, and emotionally disengaged. It is alleged that the respondent frequently insulted the appellant in the presence of third parties, including family members, friends, and neighbors. The appellant submits that these repeated acts of humiliation and disrespect amounted to mental cruelty, causing deep distress and an irreparable breakdown of trust and companionship. The appellant further avers that despite several attempts to reconcile, including the involvement of elders and professional counseling sessions, the respondent showed no willingness to continue the relationship in good faith. It is asserted that the parties have been living separately for over 4 years at the time of filing the petition, and there exists no marital bond either in law or in substance. On the other hand, the respondent wife has denied all allegations of cruelty. In her written statement and subsequent depositions, she has submitted that the appellant is exaggerating routine marital disagreements and attempting to escape his matrimonial obligations. She claims that it was the appellant who withdrew from the relationship without just cause and failed to provide emotional and financial support during crucial phases of their life together. The respondent further contends that she is still willing to resume cohabitation and has never consented to a divorce. The learned family court, after examining the testimonies of the parties, along with documentary evidence, concluded that the allegations of cruelty were not substantiated to the level required by law. It observed that marital disputes arising out of ordinary wear and tear do not amount to cruelty unless there is consistent and grave conduct causing mental or physical suffering. Accordingly, the prayer for dissolution of marriage was rejected. Aggrieved by the said judgment, the appellant has approached this court by way of the present appeal. Learned counsel for the appellant argued that the family court erred in treating the evidence as insufficient, despite clear and consistent testimony by the appellant regarding the breakdown of the marital relationship. He submits that continued separation for an extended period, coupled with persistent incompatibility and emotional withdrawal, amounts to constructive desertion and cruelty under the law. Counsel further submitted that forcing parties to remain in a marriage devoid of mutual respect, affection, or communication is contrary to the principles of dignity and individual autonomy. He relied upon several judicial precedents that have recognized irretrievable breakdown as a valid ground for granting divorce, even if not expressly mentioned in the statute. On behalf of the respondent, learned counsel argued that the marriage is still legally subsisting and there is a possibility of reconciliation. He submitted that granting divorce solely on the basis of one party's desire, without conclusive proof of misconduct or legal fault, would set a dangerous precedent. The respondent continues to maintain her willingness to resume matrimonial duties and believes that the marriage can still be salvaged with mutual cooperation and counseling. This court has given thoughtful consideration to the submissions made by both sides, the findings of the trial court, and the broader context within which the dispute arises. It is well settled that in matrimonial jurisprudence, the concept of cruelty encompasses both physical and mental suffering. What constitutes cruelty is a matter to be determined in light of the facts and circumstances of each case. The test is whether the conduct in question is such that it makes it impossible for the petitioner to reasonably be expected to live with the other spouse. While the law does not intend to trivialize ordinary conflicts that arise in marital life, it does provide relief where conduct is found to be oppressive, humiliating, or incompatible with continued cohabitation. Emotional neglect, verbal humiliation, persistent indifference, and denial of companionship over a sustained period may well constitute mental cruelty. It is not necessary that cruelty be evidenced by overt violence or aggression. Subtle and continuous acts of emotional harm may be equally debilitating. In the present case, it is undisputed that the parties have been residing separately for more than 4 years. Despite multiple efforts, including mediated attempts, there has been no resumption of matrimonial relations. The evidence on record indicates a complete breakdown in communication, absence of mutual trust, and unwillingness of the parties to make genuine efforts at reconciliation. Such circumstances, in the considered opinion of this court, meet the threshold of cruelty as recognized in established jurisprudence. Taking a holistic view of the matter, this court finds merit in the appeal. The judgment of the family court is therefore set aside. A decree of dissolution of marriage is granted in favor of the appellant under the applicable provisions of matrimonial law. The parties shall be deemed legally separated as per the operative portion of this judgment. With regard to ancillary matters, the parties are granted liberty to approach the appropriate forum. The respondent shall be entitled to seek relief under the applicable provisions, and such claim, if made, shall be decided independently on its own merits, uninfluenced by this judgment. Stop.